Malaysia having ratified the Singapore Convention very recently. I think this was just last month, right?
Yes.
Last month. So, how significant is this development for for Malaysia's dispute resolution ecosystem?
It's a very good question. It is when the Singapore Convention was first announced, there was great excitement in the air. Let me describe what has happened in 2018. There has been a very, very steady growth in the interest of mediation as a dispute resolution, not resolution, as dispute settlement mechanism in many jurisdictions. That really stems from the fact that there is a little bit of unhappiness on the dispute resolution methods that are rights-based. Because mediation is more of an interest-based provision. People are fed up saying following the legal process doesn't seem to solve problems. It's costly, it is slow, it is cumbersome. So they said, okay, and I think the moment was captured. One of the great weakness of international mediation is that it can't do cross-border enforcement. Now, the Singapore Convention tries to do that. It emulates the New York Convention. By emulating the New York Convention, arbitration is trying to emulate what arbitration has succeeded and also what the Hague Convention tried for the enforcement of judicial judgments, reciprocal arrangements. So, you ask me what is the significance in Malaysia. Malaysia basically by enacting the International Agreement Mediation Act has actually given an alternative for Malaysian parties mediating or parties mediating in Malaysia to enforce mediations, or parties from overseas who have mediated can enforce their mediation agreements, settlements in Malaysia. Now, what does it mean for Malaysia? For Malaysia, it really means that when you come to enforce your mediation settlement through the courts, it's actually done through the courts. Because you notice how arbitration awards are done also through the courts. So the New York Convention recognizes foreign arbitral awards. It converts the foreign arbitral awards into a local judgment, and then you enforce it. The International Mediation Agreement does the same thing. It recognizes settlements that's been mediated, and then it enforces it as a local judgment. So what does that mean for Malaysia? Malaysia basically saying that, look, we are going to arrange mediation. Mediation, wherever you do it, if it comes to Malaysia, it follows these rules, we will enforce. So doing business with Malaysians may be easier because you have one more option to solve your problems. The significance in Malaysia is that we have signed the Singapore Convention in 2003. We are one of those people with India, China, and we are now one of the earliest also rectifying it. Because, what we need to do, like most conventions you sign, you must have an enabling statute in your own country that allows them. So the signal basically is that if we sign a convention, we will follow. But we don't do it for all. We have signed many conventions. We have actually just paid lip service to it, sign it, create fanfare, and then we don't enact it. So this is one of the rare situations. But it suggests something else. It suggests that it wants to be a when you have enabling legislation that encourages mediation, it will also encourage local mediation. It will also encourage international mediation hub. I think this is one of the thinking behind it. I think there's nothing wrong with that. That is very, very important to have such kind of attitude. That when you sign a convention, you will carry it. But sometimes people sign the convention in the heat of it was, I must tell you all, the mediation is now very fashionable. If you look at contracts nowadays, it is very, very common to have multi-tiered clauses. Have you all realized that? The reason being, they feel that you have to use a series of methods of resolving problems to finally resolve the problem and not have only one type. So let's say if you only have, and this is ADR, right? That means alternative to the courts. So we don't talk about the courts because if you don't have any clause, then it goes straight to the courts. But courts have a limitation. It is a national enforcement arrangement. So if you are doing cross-border business, sales and purchase, even internally when you're doing it, you never know where you have to enforce it. The company may not have assets in Malaysia, but they may have it elsewhere. I think this is basically the main reason. By having this convention now rectified as a law in Malaysia, it just has now you have three options. You have the courts, you have the mediation, and you also have arbitration. The arbitration act has also been amended. I think one of the things that had been going on at my time when I went back to the center, one of the things I pushed in 2018 was the third-party funding. So third-party funding was actually, when I went back in 2023, I pushed for it and it came back. So third-party funding is done. But we actually came out with it originally in the Act, the amendment, 2018 amendment had third-party funding. But at the same time, when we signed the mediation convention, at that time, I was also pushing for the mediation convention to be signed and to be ratified. I don't understand why certain countries have signed and not doing it. Everybody is cautious. There is a little bit of worry about how this may play out. See, one of our main difficulties, maybe it should be the next question. Yeah, I'm going on and on. You know, I tell you what is the real problem people worried about? Money laundering. I'm just being, because one of the 9/11 caused a lot of problems. I think India also have a lot of problems coming out from terrorism. I mean, this is something that we all are now have to live with it. And one of the more difficult things is that tracing how people are financing these people are very, very worrying. When you make it easier to actually do cross-border enforcement, that is one of the worries, that there could be sham mediation agreements and it is paid out in, or it's paid out in India. I think a lot of people are not telling you why China has not done it, why India has not done it. My own view is that there is this gap that they cannot actually close. How to, of course, there is in the International Mediation Act, there's a provision against public policy, but that can be used. But how it's going to be crafted, only the courts can tell. And how the authorities, do the authorities say that this is a sham mediation agreement that is actually now coming for enforcement, and therefore we have to do. So all these things a bit worrying, because per se, the Act basically says we have a mediation settlement agreement. If it's signed, the mediator is identified. If it is one of those items that can be mediated, it means not following under the exceptions of, for example, consumer contracts or other types of contracts that are exempted from it, then it is enforced per se because it turns into a judgment. The moment you turn it into a judgment, you can collect the money because you can use the entire array of enforcement remedies from garnishing to deed of sale. You can do everything to get the money. So I think that is one of the things. So this is my suspicion. People are not talking about it, but I think the gap has not been closed. Because when you drafted the Singapore Convention, people did not actually deal with that. And,
So I think that's a very significant point that you have made. But I think from my understanding, one of the concerns in India is that when mediated settlement agreements are to be enforced, it gives very little judicial control over the over the agreement
what's
itself.
supposed to be efficacious.
It's supposed to be, yes, exactly. That's the whole challenge. Because of the perhaps the mindset of what you.
Okay, I'm trying to understand.
Yeah.
They feel that there is no judicial oversight.
Yes.
Over
Yes.
the thing, but that's what it's meant to be.
I think perhaps perhaps the obsession about adjudication, because being a common law country, we are obsessed with judicial adjudication of all matters. So perhaps that is one reason why. But what I think I would like to ask you about is from the Malaysian perspective. How do you think this ratification of the Singapore Convention is going to impact business in practical terms, especially from the perspective of foreign investments, foreign trade?
It just gives another option. The ease of doing business is how you resolve it. If you see the ranking of ease of, you ask the ranking for the business people, how they do the ease of doing business. One of it is, how good is my court system? How good is my way of resolving a dispute if I have a dispute, let's say, in that country? So your ranking, so you find the highest ranking are the people who have dispute resolution mechanism. Either their courts are considered excellent and they do it very, very fast. That means there's not a big docket, cases overhanging, and then the judges are going to be corruptible. And more importantly, they are also very sound. So they become more like Singapore is always up there. They are a small country. Don't have kind of things. They deal with customs. Whereas India may not. Malaysia is number 25. Normally we are between 25 to 25. We keep on swinging. Some days we are doing well, some days we are, it depends. Ours is more to do with the perception of issue. One hand, especially political cases. Then the second thing is that the bureaucracy may not be so efficient. So in fact, how you clear that becomes problem. One of the factors is that I think we have a government who is very, very interested in putting the ranking. So what does it mean to us? It means actually a number of things. One thing, there is a boost, all the institutions that are doing it. But you notice that many of the institutions that are doing mediation are also dual. They normally do arbitration. They do, in Malaysia, we do adjudication, construction adjudication. So I think that will be given a boost. In fact, the Bar Council, the number of other institutions have set up specialized mediation courses. The other thing is that there will be a demand for trained persons. So training becomes very important. Accreditation will become very important. So everything will start I think it just creates momentum. How it's going to play out, we don't know. We really don't know. But again, how does there's some discretion or in the judiciary in deciding whether to enforce. So how they interpret public policy is going to be also very interesting. And when they have a hard case, how they're going to deal with it.
Perhaps one of the things that should offer solace to people is that the Singapore Convention deals only with commercial disputes. It does not deal with other kinds of disputes, for example, family disputes, cross-border.
Family disputes,
Yes.
Inheritance.
Yes, inheritance issues.
Consumer, no.
Yeah.
And then it also doesn't deal with judgments. That means you have a judgment. If it overlaps with a settlement agreement, it will not be actually. It will be one of the items that are cannot be mediated. And then the other one is arbitral awards. That must go squarely under the New York. So they have that limitation. But the other thing is
do you regard that as limitation or as safeguards? Because especially given the context of what you mentioned just now, that the possible misuse of for the purpose of money laundering.
It could be safeguards, but they also want to make sure that small and things that are not, which should go to the courts, should be left there. So I think, consumer disputes, if every consumer dispute is going to be mediated and cross-border thing, it is, of course, some of the consumer disputes could be very big. Depends what you're buying. For you, it could be very big, but we always see it's a very, very small. And they try to encourage the setting up of specialized consumer dispute tribunals and also arbitrations, online arbitrations, for example. That is actually very, very cheap and it's done very, very fast. So it could be safeguards rather than limitations.
The other point also is that, there are, insofar as consumer disputes, for example, are concerned, or intellectual property disputes, all these are covered by the WIPO rules. And then the EU itself has evolved some rules for has, provided the mechanism, especially online dispute resolution for resolving consumer disputes. Yeah.
They are all arbitrary.
No, mediation.
Oh, they have mediation.
They have mediation.
Of course
they have mediation rules.
Actually, every institution, every country is actually working out a stepped procedure. So for me, every country will eventually, the whole world will have that. It have to have a step. That's why I say contracts now. You see, even a simple international contract or whatever contract, they always are multi-tiered. So they will have, let's say, for example, a decision by somebody. After that, they will have amicable settlement. That is mediation. Then after that, they may have a adjudication arrangement, which is not arbitration, adjudicatory and expert determination. Then after that, they will go to art. So they try to sort of confine the dispute and keep it cheap. Try to resolve it then. But one great advantage of mediation is that it does things that what arbitration cannot. Because it is a compromise. So when parties compromise, normally they will continue to do business. When parties fight, the arbitration very difficult for them to do business. So it is something that maintains the business relationship, and you can look at solutions that are a bit more different. So a this is the other thing. Mediation settlement can be not of that dispute, arising out of that dispute, another item. Let's say another contract, I give it to you, and that will be in the mediation settlement, and that can come for enforcement. I didn't get the other contract. Therefore, I need to get the other contract.
I think the other advantage, I don't know whether you would agree with me on this if I say that any adjudicatory process requires, the dispute to be couched in terms of rights and wrongs, in breaches, and the relief in terms of compensation damages. So, what happens when you're in the process of, for example, when you're filing a claim statement? You have to make a lot of allegations. You have to, just the facts to bring that into the framework of law in order to be able to claim the relief. That process can be avoided in a mediation because mediation is more from a problem solving perspective.
I know, I agree.
Yeah.
The entire method of a rights-based approach is to find fault. Who is at fault? After you find the fault, the law creates a regime of how damages are calculated. So if you go towards that approach, there will always be somebody at fault. And that creates ill feelings. It's because someone wins and someone loses. So sometimes they say mediation, both sides win or both sides lose it, so that they can carry on doing the business.
So there's a shift from a fault-finding paradigm to a problem solving.
Yeah, it's an interest-based thing.
Interest.
What is the common interest of the parties and how we can maintain it.
So how do you see the role of institutions in this, especially in the context of these resolution of cross-border trade disputes, cross-border commercial disputes? How do you see the role of institutions like AIADR and there's one more institution?
I basically think in every country, wherever there is an institution, it cannot be only offering one type of dispute resolution. Of course, there's various models of doing it. Some countries say that institutions will specialize, like Singapore. They will say that SIAC only does arbitration. The Singapore Mediation Center will do mediations, and then they will have an international center to do other things. But many of the other countries don't have that luxury, that one institution should be able to do everything. So I think the future will be all institutions will offer, just like the ICC, they will offer mediation services. They will also offer arbitration services. But sometimes when the emphasis change, they will do those kind of things. The second thing is training. The emphasis since for the last 10 years has been on the training of mediators. You will find that if you want to be, in fact, I used to make a joke about, because all these structures are not occurring, but there's so much optimism of how mediation is going to solve problems. And it can happen. So people are training, but they have no mediations. So I think that, like, when you do this kind of reform, legislative reform, then the mediations will happen because it becomes something that is efficacious because it can be enforced. The moment you can enforce it, if there is utility. If you cannot enforce, especially you can enforce cross-border, and I'm hoping that many more countries will actually rectify and create the enabling statutes in their own country to allow mediation to really take hold.
So what would your advice be to India? What is the way forward? Having signed the Singapore Convention.
No, in fact, I was thinking about it. Somebody asked me, I said, India is a very big country. So I personally feel, if I was looking to set up to make it work, then you must have a national plan to look at all of dispute resolution. You see, you all always talk about wanting to make India up. Niti Ayog, right? They also
it's a planning commission.
I came for the conference at that time, and they sought me out and asked me for my views. And I said that basically at that time, you must have a more even development. it's very important.
I think setting of standards also becomes very important there, isn't it?
I think
Because when you
an attempt, Indian what is that? Arbitral Council, Indian Council of
Arbitration Council
Arbitration.
of India.
They tried to do that, but there was a reaction. There's a reaction, and I can see why the reaction comes, because there is no, like my country also lah. Everybody is very suspicious of each other. Whenever somebody does something, they think that you are doing it for yourself. So I think that is the other problem. So there has to be actually a kind of debate that we want to be a hub. How do you become a hub? You just don't set up one institute and say we are a hub. You don't set up one legislation and say you're a hub.
No, that's fine. If you set up an institution and say, at least one institution and say we want to be a hub, I can understand. But you just talk from the podium, we want to be a hub. Beyond that, nothing happens.
No, I think, like, for example, arbitration. India has been very consistent for the last 10 years. It says that all our disputes are going out. Our real core disputes are going out. And they are going out to Singapore, they are going out to ICC, they're going to London. They are anywhere except in India. And they are using Indian law. And then they are actually being decided elsewhere and is coming back for reinforcement. But I think that there is a reason for that. Because when you look here, people don't have it. It's a confidence issue. But how do you create confidence? First, you must have the institution. The institution must function. It must go on for years, and you must support it. And I think for me, if you ask me, India must keep its own arbitrations in. That's the key. Your domestic arbitrations must not go out. It must be resolved in the country. Your international arbitrations you give a choice.
We need for dispute resolution, as Dr. Raju suggested, a clear-cut policy framework that provides for the establishment of autonomous institutions. Now, I'll just tell you how, for example, if you look at the IAMC structure, IAMC is financially supported by the government of Telangana, but it functions completely autonomously. There's a board of trustees consisting of retired Supreme Court judges, but they don't interfere in the day-to-day management. It is professionally run by qualified, trained professionals. So we have case managers, we have registrar, we have deputy registrar, we have associate counsel, we have other, administrative people who are running the show. Now, there is no interference either by the government, which is very important because, see, many government disputes come for resolution. And if you are associated with, if the government has a controlling interest in the institution, if it has actual control over the institution, then the faith of the litigants is compromised because they will not trust the institution. They won't trust. So this model is what was even recommended by the high-level committee, which was constituted by the government of India in 2017. So this model is what we feel should be replicated in every state in the country, because that is the only way we can tackle the issue of pendency. Because as one very important suggestion, which completely aligns with my own thinking, is that dispute resolution, you should identify what are the disputes that should not be coming to the courts. That should be going only to the institution. And you apply the hybrid processes. You have mediation. If the mediation fails, you go for arbitration. Or you have the ARB-MAD-ARB model, which Singapore also found. So that is the only way forward, because that's where I feel that, the court annexed mediation system should be confined to whatever the pending litigation, but the courts should actively look at referring complex disputes to institutions which are better, in a better position, because they have better trained people. They can manage the cases in a more efficient manner. And there is a lot of transparency. And that's where we need these credible institutions to come up. I think, do you agree with that?
No, yeah, I agree with most of your statements. But it is, the inertia is going to be very difficult. I think that you pointed out one interesting thing. Many societies are litigious simply because access to justice is very easy. So how certain countries have actually overcome that. They raise the prices of going to court. So if you go to the Supreme Court, your filing fee is so much, and you are given, let's say, 1 hour free or 2 hours free, then the rest will pay. So the person who loses end up paying. So they think twice. In Singapore court, they do that. They get 1 day, 2 days free, and then the rest they have to pay. They have a rate. And then the filing fees are higher. But that, again, it sums up to cause problems of access to justice. I think the great Indian great democracy, which is very, very unique in the world, is the power of the courts and the prestige that the courts have. So I think you can't lose that. That one is a different thing. Only thing, it becomes more efficient, it will be even better. So you can deal with the main things, and the smaller cases, everybody helps out. In fact, I personally think court annex mediation is the way out. You give an option. You can come for mediation. Complex things, you can come for mediation first and go to the courts, but all matters will be mediated first. And if it cannot be solved, and there will be a fee that will be paid for that when you file it. And part of that fee goes, instead of going to the court or the central treasury, part of it goes to the development of all these institutions. So it will be a way. But I think this one, again, there has to be central planning. Somebody in the central government, union government, must sit down, get the actually the best people are the economic planners. They can do it very well. If you give them the task and you tell them what you want to achieve, they will do it very well. You say, I want access to justice, or I want a diversified thing, take the load off the courts.
So, Dr. Rajoo, thank you very much for this very enlightening and insightful discussion. So the key takeaways for us from this is that India needs a clear-cut policy framework in the first place, a national plan to implement a proper system, institutional system of dispute resolution, which has the credibility and trust of the people. And the focus should be on first the domestic, resolving the domestic disputes. And then we can look at, once we have a strong institutional framework, then we can look at the international disputes, because that will create the faith and trust and credibility of the system.